Welcome to this presentation covering Chapter 6 of our textbook. This chapter relates to legally managing property. So let's get started. So we're going to discuss a little overview about property generally, what it is, what the different categories is, how they compare to each other. And then we'll talk about purchasing property. And related to the topic of purchasing property is how are you going to pay for the property? How are you going to finance it? I mean, sometimes you can pay cash for it. That's easy. That's a pretty direct transaction, but sometimes you don't have the coin. And so you need to get involved in financing. And so that's our third topic to cover. And we'll cover these three during this lecture. And then a subsequent lecture, we'll talk about the last two topics, leasing property, and we'll also talk about intellectual property rights. So let's get started. Here are the chapter objectives. I'm not going to spend time on those, but they're probably a good way to review at the end of the presentation. If you feel like you can distinguish all of these 4 or 5 characteristics, you will be in good shape. So let's begin talking about property. Okay, so we're going to divide up the world of property into 2 categories, personal property and real property. This is how legal professionals think about property, whether they're talking about hospitality issues or another area of property law. So this is kind of a universal distinction. When we talk about personal property, we're going to divide it up into 2 categories, and this is pretty common, to tangible property and intangible property. Again, these concepts aren't unique to hospitality law. They apply to lots of different areas of law, but they certainly are relevant to hospitality law. So let's continue in our discussion. We're going to talk, I guess, initially about the real property characteristics. So what is real property? Well, it's land, it's dirt, and it's the stuff that is attached to dirt. So this would be buildings, this would be trees, fences, things along those lines would be real property. Another term in the area of real property is real estate. They have subtle different meanings in the law, but for this class we're going to treat these 2 terms as synonyms. So I'm not going to make a legal distinction between real property and real estate. So we don't worry about knowing the subtle shades of meaning there. So now we've talked about what real property is. It's land and the stuff that's permanently attached. Now we're going to talk about this first topic, which is personal property. And personal property, sometimes when I see that term, I think, well, it's about an individual and what he or she owns. No, that's not what it's about. It's what it sounds like it's about, but it's everything that isn't real property. Now, of course, I can own real property, and I, a person who owns real property, that real property is my personal real property, so you could call it my personal property. But that sounds like nails on a chalkboard to an attorney. Personal property is by definition not real property, and real property is by definition not personal property. So don't get too tied in knots about the idea that a person can own property and that property could be real. That's just not how a legal professional thinks about it. So sometimes it can be tricky to decide whether something is real property or personal property. For example, imagine that you have a mobile home. When the semi drops off the mobile home at your land that you have purchased, and it is sitting there waiting to be attached to the plumbing system and the electrical system and the water system, it is not real property because it isn't attached yet. It is not permanently attached. Once it is, then it becomes realty or real property or real estate. Now, it is true that you can move a mobile home. You can disconnect it, but you are in some sense fundamentally changing that real property in that sense. So usually we think about mobile homes that are attached as being part of the realty or the real estate or the real property. But let's say I had an RV, and I oftentimes keep my RV at this land, but I don't always keep it there. And even if I keep it there all the time, it's on wheels. It can move. Well, no matter how many years I keep it there and don't drive it away, it is always going to be personal property because it's not attached. So we will talk more about some differences in this area, but we're still going to talk about personal property right now. Again, going back to our schema, we have personal property. Under personal property, we have two subcategories. We have tangible personal property and intangible personal property. So what is tangible? Tangible literally means touchable. If I can touch it with my hand, it is tangible. Now, obviously, real property is got to be tangible. I can touch the dirt, I can touch the brick, I can touch the tree. All of that is tangible. But when we talk about tangible property, typically we're talking about tangible personal property. And this would be a pencil, a computer, a car, a stove, a table. Things that literally you can put your hand out and it has contours, it is touchable. And again, this is not a term that's unique to hospitality law, but it's certainly relevant to hospitality law. So if we have something called tangible property, you've probably already guessed it, there's something called intangible property. This is personal property that can't be touched. And it's not like, MC Hammer saying, can't touch this. That's not what we mean. What we mean is something that doesn't lend itself to touching. For example, my copyright interest in that hit song that I wrote. You can't touch my copyright interest. I mean, you could touch a CD that had my music on it. You could touch the sheet music that I wrote. But that doesn't really represent my copyright. It's just an example of a manifestation of my copyright. And so intellectual property is inherently intangible. Money is inherently intangible. Yes, it's possible for me to go to my bank and withdraw $100, and I might have, say, 5 20s, and you could touch each one of those 20s. But it is also intangible in the sense that I can have $100 in the bank, but I don't have anything to touch for it. Yes, I can go to my ATM and print out a receipt for that money. Sure, I can, but I don't need to have an ownership interest in it. Another example of intangible property, which is perhaps even more relevant, is a business's goodwill. Let's say I own a taco stand. People love my tacos. People come from far and wide to eat my tacos. I've decided that I want to retire from the taco business, and so I'm going to sell Bob my taco stand. There are some assets with it. I've got some tables, I've got a cash register, I've got some skillets, some pans, some refrigerators, some other items in my inventory. All of that stuff, if you were added all together, is worth about $100,000. But you know what? When I negotiate with Bob, I negotiate a price of $225,000. And frankly, Bob is lucky to get it for that price because he's buying not just the table and the cash register and the knives and the forks and all that good stuff, although he's certainly buying that. He's also buying my business's goodwill. There are people who come to my taco stand every day for lunch or breakfast, and they will continue coming to the stand even after I cease to own it, as long as Bob treats them right. They may not even notice for a time that there's a new owner. Perhaps my staff may continue working for Bob, and so it may be a seamless transition. Assuming Bob doesn't screw things up, those customers will keep on coming. That's what the business's goodwill is. You can't touch it. It's not a knife or a fork or a cash register. It is the reputation I have. It is the customer base that I have. And that is definitely many times a good business asset. Let's talk about improvements. These are real property. You can see here we have been having the term personal. Now we're switching to real. An improvement is something that enhances the value of the real estate. So an example would be a building. Let's say I build a freestanding garage on my land. That will increase the value of my land. Or let's say I make an expansion to my restaurant. It used to seat 30 people and now it seats 50 people. Well, that's going to increase the value of my business and also of my land. So those would be examples of improvements. Let's say my restaurant currently just has a gravel parking lot. I decide to make it a asphalt or a cement parking lot, I find that that is going to increase the allure that my restaurant has, and maybe increase the clientele that I have. And so that would be an example of an improvement to my business. Okay, so now we're flipping back to personal, and we're going to talk about chattel. Chattel is personal property that isn't real property. It can be movable or it can be immovable. It's usually going to be tangible. In fact, I'd say it's always going to be tangible. Um, so this could be a car, furniture, a painting. Those are examples. It can also be something that is not easily moved, but still isn't real property. For example, let's say I purchase a grand piano for my restaurant. It weighs an awful lot, and maybe I've even constructed the walls in my restaurant such that I wouldn't be able to remove my grand piano unless I were to remove a wall. It just wouldn't fit. So it seems like it's pretty permanent, but you know what? It is not physically attached to the floor or the ceiling or the walls of my restaurant. So it is still chattel, even though it is very difficult to move. The standard is, can I move it without harming the real property? Now, in my example, you could say, well, you really do have to harm the real property because to get it out, I'd have to take down a wall. But I could chop up my grand piano, couldn't I? I mean, I probably don't want to do that, but there are ways of getting it out the door that would not interfere with the value of the real property. So most likely that grand piano is chattel. A closer call would be something that I actually, excuse me, a less close call would be something that I could slide through the door, even though it might be very, very heavy and very unlikely that I would routinely move it. It would still be chattel. Let's talk about fixtures. Fixtures are stuff that once upon a time were chattel, but they've stopped being chattel. You could make an argument that my grand piano has become a fixture, especially if I have attached it to the ground. You could even make an argument that it's a fixture as soon as I put up those walls that it wouldn't go through. But let's see what the technical definition for a fixture is. An article which, and so this is the personal property, which was once chattel, so personal property, but that has become a part of the real property because the article is permanently attached to the soil or to something attached to the soil. So if I have a chandelier, until I attach it to my ceiling, it's chattel. But once I attach it, it becomes a fixture. Same way with an oven, a window air conditioner unit, a water heater. Once they're attached to the system, or my mobile home, for example, it becomes a fixture, and therefore it becomes part of the real property, the realty, the real estate. Okay, so an important term, whether we're talking about real property or personal property, is the idea of title. A title is what you think it is. It's a term that we use pretty commonly, even when we're not talking about legal things per se. It is the sum total of all legally recognized rights to the possession and ownership of property. We oftentimes think, especially when we're talking about real property, we think about a title or a deed that demonstrates that. When we're talking about personal property, we usually don't, unless it's a motor vehicle, we usually don't think about actually having a piece of paper. We might have a receipt. If I go to a Kroger and buy a loaf of bread, my evidence that I own it is the receipt that I got from Kroger. But I'm probably not going to keep it for that long. Maybe I'll keep it to look at it to make sure that the cashier ran it correctly, or maybe keep it long enough if I'm thinking maybe I'm going to return it. But I mean, loaf of bread doesn't have a very long shelf life. But let's say it were an article of clothing that I bought at Kohl's. I might have that article of clothing for several years. It's unlikely I'm going to keep my Kohl's receipt for very long. Once I've decided, yeah, I'm going to keep it, I'm not going to return it, I'm probably not going to keep the receipt at that point. So we can talk about title when we're talking about having a document, but we can also talk about title when we don't have a document that evidences title. Okay, so what is the document that we talk about that evidences title when we're talking about real property. Many times that's going to be a deed. What is a deed? We're talking about a written document that shows the transfer of property or land, not just real personal property, but real property, from one person to another. And the information we're going to see on the deed is we're going to have the date that the transfer happens, the names of the parties, who's selling, who's buying, the consideration involved. Again, this is the purchase price as well as a description of the property. The description of the property indicates the consideration that the seller is giving. This is what he or she is giving up. And the price is what the purchaser is getting. We can have a deed of two flavors, so to speak. One is a warranty deed and one is a quitclaim deed. So let's look at those. The warranty deed is the more common one that you'll see, certainly in a business context, but even in a personal context. So this deed not only says, I'm giving you all of the ownership rights that I have, it's also saying something more. It's saying, and I represent to you that I do in fact own this. And so you're getting a pretty good deal here. And if it ends up that I'm a big fat liar and I really don't own this, you can sue me because I have breached the warranty that was part of my deed. We'll talk more about warranties a little bit later in this lecture. But that's the idea behind warranty deeds. You're getting something extra. You're not just getting what that person is saying that they own it, but you're also getting their warranty. You can also have a deed that doesn't have the warranty. We call this a quitclaim deed. This is saying, look, I've got some rights to this land, but I'm not quite sure what they are. But everything I have, I'm giving to you. It may not be that much. It may be pretty cool. It may not be so cool. But if it ends up that it's not so awesome, you can't sue me about it because I'm not promising you what the rights are I have. This is oftentimes done when land maybe has been moved around from one party to another, or somebody has alleging adverse possession or something like that. You don't find this a lot in commercial transactions. Usually there will have been a lawsuit to finally adjudicate ownership interests. So you'd eventually be able to get a warranty deed at some point. So this is an option, but it's not one that most business people are that comfortable pursuing. So let's assume that you find a piece of property and you think you want to buy it. You've spoken to the owner and they want to sell it to you. You've agreed on a purchase price. What are you going to do? Well, one thing you're going to want to do is probably buy some title insurance. And the title insurance providers are going to do a title search. They are going to want to confirm, because what they will be doing through this title insurance is saying, listen, we've researched this and we really do believe this person really owns it. And if it ends up that they don't really own it, my bad. I'm on the hook for this. I should have told you that this wasn't a good deal for you. And so I am insuring the fact that this person actually owns it. And of course, the title insurance company is going to do a title search before they do that to make sure. And they're not going to issue title insurance if, in fact, the person who purports to own it really doesn't have a clean title. Title insurance is a smart thing to buy even when it seems to be pretty obvious who owns this land, because there can always be surprises along the way. I'll give you an example from my personal experience. When I was a teenager, my parents bought a new house from a builder. The builder was going through some financial difficulties. And so my parents were able to get a pretty good deal. The builder had several houses in its inventory, and it was wanting to clear them out because it was having cash flow problems. I think the builder ultimately went into bankruptcy sometime after my parents closed on the house. Well, whenever you're going to get a mortgage, you're going to have title insurance, or the mortgager isn't going to agree to it. So my parents definitely had title insurance. Well, at some point, several months later, my parents were sued for a microwave that was part of the house. It was a fixture of the house. It had been chattel, but it had been physically attached, put into, I guess, above the oven in the kitchen. And so it became a fixture, part of the real property. Anyway, my parents referred that matter to the title insurance company, and they became responsible for resolving the issue because the title insurance company was ensuring that, in fact, the owner owned all of the fixtures that were part of the building, and it ended up that I guess the owner hadn't fully paid for that microwave, and when it went bankrupt, it had not satisfied that judgment. So it can happen even in pretty routine transactions that you do need and use that title insurance. You don't want to, but just like any other insurance product, you plan for it and hopefully you don't need it. Okay, bill of sale. And now we're flipping back to personal property. This is the document typically that is used when you're having personal property and you're transferring it from the seller to the buyer. It's going to have the same type of information that we see in a deed. You're going to have the date of the transfer, the names of the parties, the consideration, what is the buyer, going to pay for the item, and then a description of the item. The bill of sale, or maybe the receipt in this case, it qualifies as the contractual agreement, and it can take many, many forms. One example would be a receipt, but there can be other means of doing that. Typically, again, with personal property, you're not going to have a formal title document. An exception would be motor vehicles, which are obviously tangible personal property, but there are things of significant value that are very movable, and so people want to have a record of who owns what. That's one of the reasons why we have the VINs, or the vehicle identification number, so that it makes it more difficult for people to flip cars illegally when they don't actually own them. Okay, so I promised earlier that we talk a little bit about warranties. Remember we talked about the warranty deed? Well, here's the payoff. We're going to talk about warranties. When we were talking about warranty deeds before, we were talking about it within the area of real property. But now we're going to talk about warranties in the context of personal property. So what is a warranty? Well, it's a promise about a product made by either the seller of the product, could be Walmart, could be Target, could be Bob Smith, your next door neighbor. Or it could be a promise made by the manufacturer. If I'm buying a Toro lawnmower from Walmart, Walmart might be making the warranty, or Toro might be making the warranty. So anyway, it's a promise about the product made by either a manufacturer, the maker, or the seller that is part of the sales contract. It is part of the reason you buy that particular model lawnmower. You like what the promises are that Toro has put behind it. That is maybe one of the features that made this particular lawnmower appealing to you. You might have paid a little bit more for it, and that becomes part of that transaction. Okay, well, we can break down the world of warranties into lots of different ways, but one way of doing it is to look at express warranties versus implied warranties. Many times I think when people see express warranties, they're thinking, oh, this has to be something that's in writing. Well, certainly warranties often are in writing. I mean, that's a smart way to present a warranty if you're the manufacturer or the seller. And if you're the buyer, you certainly would like to see the warranty in writing. But warranties don't have to, even express warranties are not restricted to things that are in writing. There can be oral warranties that are also expressed, because here we have a statement of fact about the capabilities and qualities of a product. So let's say when I am at Best Buy and I'm comparing, say, two different cameras, and the salesperson there is describing to me features. Well, this camera has this, this, and this feature, and this camera has that, that, and that feature. Well, that information isn't maybe available to me in written form, but it's those commitments, those statements made by that salesperson become an express warranty, in this case, not of the manufacturer, but of the seller. So express includes both written and verbal commitments. Express warranties are important, but implied warranties are also important. These are unwritten and, in fact, unstated directly expectations that a product is free from defects. If I go to Walmart and I see a box that is a hairdryer, I am going to assume that I can plug it in to a wall in Frisco, Texas, and it will dry my hair. If I go home and see that it's actually an item that was designed to be plugged in Europe with a different, obviously, electrical system, that's not going to be very convenient for me. Or if I take it home and I see that, in fact, it looks like a hairdryer, but it doesn't actually blow air and won't actually dry my hair. It's like a scene from a prop for maybe a movie or something that doesn't actually function. I will find that under either one of those circumstances, the implied warranty has been violated. There may not be anything in the box that says this hair dryer actually blows air, or this hair dryer actually functions with the electrical system that we have in the United States. But we all understand that that is part of the transaction when you sell a hairdryer in the United States. And if I don't want those implied warranties to apply to my product, then I better say on it, hey, guess what? These don't work this way. Sometimes you'll see this on children's products. You might see a children's lawnmower, pretend lawnmower that little Bobby or little Sally can used to mow the grass. Well, obviously there's not a real lawnmower in it, and you can usually see by looking at it, hey, this is not going to have a real lawnmower in it. It's not going to have a real sharp blade because, it's for kids. But probably on that box somewhere is going to be some statement that says, there's no implied warranty that this will cut any grass or something like that. Common sense would tell you it wouldn't, but they would probably also state that because they're using words like lawnmower, which might be interpreted to have an implied warranty that this will actually cut grass. So let's talk about the UCC for a second. We've talked about it in the past, but just a little refresher. The UCC, of course, stands for the Uniform Commercial Code, and it requires two things from personal property sales. And of course, the UCC has nothing to do with real property. So when I say it's to do with personal property, we have to, again, think about what is the scope of the UCC. The scope of the UCC, again, deals with contracts for the sale of goods, stuff, personal property, and in fact, not even all personal property, but just tangible personal property. That's what we're talking about when we're talking about the UCC. If we're talking about all the other stuff you can buy, intangible personal property or real property, we're going to have to look at the common law or some statute. The UCC is not going to provide any support into those areas. Okay, so let's just have that as a background fact when we go down and talk a little bit about what the UCC provides with respect to warranties. We said before that warranties are implied warranties are just that, implied. They are not expressly stated. The common sense tells you, I can count on this item performing this particular task or not doing this particular thing. And so what are the two warranties that the UCC says apply to all personal property that is sold? Well, one is a warranty of merchantability, and that is the warranty that the item will be in good working order and will adequately meet the purposes for which it was purchased. So again, going back to the hairdryer, when I buy the hairdryer and I turn the on switch and I've plugged it in and it doesn't come on, and then I look inside, oh, wait a second, there is actual no motor inside. Well, guess what? It looks like a hairdryer, but that's not what I wanted. I didn't want something that just looked like a hairdryer. I wanted something that was in good working order. So that item breached its warranty of merchantability unless, of course, the seller had disclaimed the implied warranty. The seller can do that. You may see this in a garage sale where excuse me, everything is marked as is. You get it as you get it. If you don't like it, don't buy it. That's the idea here. So that's the warranty of merchantability. Let's look at the other warranty. This was a little bit more subtle, a little bit more difficult to get one's head around. This is a warranty for fitness for a particular purpose. You can get it a particular purpose in two contexts. One can be a seller focus. So let's say if I am, if I have my, again, the hairdryer has made this, I'm a manufacturer of a hairdryer, and I have a picture of somebody blow drying their hair as they are taking a bath. Well, the implication on that product or picture that is appearing on my product is that this is a safe way for me to blow dry my hair as I take a bath. Well, we all know that's highly dangerous because if I drop it, I'm probably going to get electrocuted. So that would be indicating somehow or another this hair dryer, even though it's plugged in, is somehow safe to use in the bathtub. And let's say I look at the picture and I think, wow, this is a neat feature. Now I can dry my hair as I take my bath. A little bit of an interesting decision to make, but I'm persuaded the picture is saying that this is safe. I actually do it. I accidentally drop the hair dryer in the bathtub. I electrocute myself. My husband sues the the hair dryer manufacturer, and he'd probably have a pretty good claim because the picture indicates I ought to have been able to do that. So that's one way you can get a warranty for fitness for a particular purpose, by the pictures, the advertisements, the representation that the manufacturer makes. But there can also be unique warranties that happen because of what the buyer represents. Imagine for a second that I have always wanted to bicycle ride to Europe. That's been a dream of mine. And what I'd like to do is I'd like to take off at around Hilton Head, South Carolina, and just bike across the bottom of the Atlantic Ocean. So I head on over to Richardson Bike Mart, and I'm looking at all their bikes, and they've got all kinds of bikes. They have tricycles, they've got mountain bikes, hybrid bikes, road bikes, all kinds of bikes. So I talked to one of their salespeople, and he goes, "Well, what kind of bike are you looking for, ma'am?" And I say, "Well, I want to take this bike to Europe." He goes, "Well, that's a wonderful thing to do. There's lots of wonderful trails in Europe." And I go, "No, you don't understand. I want to bike this to Europe. I want to go under the Atlantic Ocean." He goes, hmm. He looks at his inventory and he says, "Well, you know what? This is the most sturdy bike that we have. If any of our bikes can handle the bottom of the Atlantic Ocean, it would be this one." I say, "Well, are you saying it will be able to handle the stresses and the pressure at the bottom of the Atlantic Ocean?" And he says, "Yes, I think it will." So I say, "Okay, I am decided to purchase your bike." I purchase the bike. I go to Hilton Head. I start biking in the sand, and I enter the ocean, and I go with my oxygen on. And you know what? It doesn't work. I cannot bike on this bike to the Atlantic, over the Atlantic Ocean. It falls apart very, very quickly. It cannot handle the stress, the pressure underneath the water. And so therefore, guess what? I can now sue Richardson Bike Mart for violating the warranty for fitness for a particular purpose. That bike salesman was mistaken. What he should have said is, we don't have a thing that will do that, ma'am. We are not going to be able to meet your needs. That would have been an honest answer. As I said before, the seller can disclaim any express or implied warranty. There's specific procedures that have to be followed in that area naturally. We're not going to talk about the ins and outs of that. Okay, so now we're going to talk about financing the property. We've talked all about the ins and outs of buying it. We talked about the different types of property. Now we're going to talk about how are we going to finance this property. One important idea in this area is a lien. What is a lien? A lien is a claim against property that gives the creditor, and another name for the creditor is lien holder. He is holding the lien, in other words. So let me start again. A claim against property that gives the creditor the right to repossess and or sell that property if the debtor does not repay his or her debt in a timely manner. So let's kind of go through a scenario. I buy 50 tables for my restaurant. Each one of the tables is $1,000, and so it's going to be $50,000. I don't have $50,000, so I have a loan. I go to the bank, I put down $10,000, and the bank loans me $40,000. So I'm able to purchase the tables, and the banker becomes my creditor, the lien holder. If I don't pay promptly on my debt to the bank, then the bank has the right to repossess those tables, and if it wants to, sell those tables for whatever money it can make if I don't pay my debt. You can see how that works. Not a big surprise there. We probably all heard about those type of situations. So another way of looking at a lien is it's the right of a person to retain a lawful interest in the property of another until the owner fulfills a legal duty. So the person in this situation is typically going to be that creditor. There are special types of liens that apply not so much in the creditor, well, directly in the creditor situation. These would be mechanics and construction liens. So let's say that I am a mechanic who does a repair on your house. And as a result of the repair, um, your house is now functioning. Your house is better than it was before. It's now a nicer place to live. You don't pay me. Well, that's a bummer for me. I want you to pay me. So what I might do when you don't pay me is I might put a mechanic's lien on your house. That doesn't help me in the short term because, I can't, you probably have a homeowner's exemption on your land, and so I can't force you to sell your land. But when you do sell it, you're going to have to, first of all, the first money you get from the buyer is going to satisfy any of these liens that have been perfected against your land. And so I'm first in line. You might not sell it for 20 years, but when you do, I'm going to get my money. Collateral. Obviously, this whole discussion about liens relates to collateral. That's property that is pledged to secure the repayment of the debt. So the collateral for my tables that I have purchased would be the tables. It's a pretty common thing that what you're buying becomes the collateral. Collateral, again, here's another way of phrasing it, is an asset a person agrees to give up if he or she does not repay a loan. Collateral doesn't have to be what you are buying for the money, although it oftentimes is, but you can use it for some other purpose. So for example, I could take out a second mortgage on my house so that I can go on a honeymoon. Obviously, the honeymoon purchase has nothing to do with the house, and yet the house would then become collateral for that honeymoon loan. If I don't pay the honeymoon loan, then the bank, the one who extended me the credit for the honeymoon, would be able to collect on my house. To perfect a loan. In this situation, we're using perfect as a verb. So we're not saying perfect, it's perfect. When we use the term perfect, we don't mean make something perfect in the sense of make it without any flaws, but we mean make it whole, make it without any errors, or make it complete. So to perfect a lien is to get the lien into the condition it needs to be in so that it is in fact a lien. And how do you perfect a lien? We've got to make a public record of the lien. Or if you can't make it a public record, you have to take possession of the collateral, which usually isn't really what you want to do because, again, going back to the example of the tables, if the bank has the tables, I can't run my restaurant. So that's not very helpful for me to have a loan to buy tables if the bank is going to keep the tables. But the bank is probably going to want to have a public record of the lien in the event that I don't pay the bank back. The bank is going to want to be able to get the collateral back. The bank in this situation, because it has a perfected lien, is going to be a secured creditor. The collateral is the security, those tables in this case. So an example when we're talking about real property is a mortgage, and we're all familiar with this term. It is the pledging of real property by a debtor to a creditor to secure payment of a debt. So this is a particular example of a lien. So a mortgage is really a type of lien, but it applies to real property. A mortgage is a term that we use all the time, but actually it's not what we do in Texas, strangely enough. But we do something that is essentially the same thing. So because the term mortgage is used in more jurisdictions than not, we use the term here in everyday conversation. But the actual thing that's happening is what's called a deed of trust. A deed of trust places legal title to real property in the hands of the trustee, the person loaning the money, until the debtor has completed paying for the property. So in this situation, the person who is owning it as a trustee for the benefit of the debtor as long as the debtor keeps on paying. It's just a different way of imagining the mortgage type relationship. And as I said, Texas happens to be a deed of trust state. It's just a different terminology. It really gets you to the same end game, so to speak. So what is a security interest? Well, that's a legal ownership right to possession. So a security interest could be the mortgage, it could be the lien, it could be those tables or that house that I'm using as a mortgage, either my first mortgage or a second mortgage. So in a security agreement, obviously a security agreement is about the security interest. So obviously a security agreement is an agreement or a contract between a lender and a borrower that states the lender can repossess, get possession back of whatever that collateral is, whatever that personal property is that the person has offered as collateral if the borrower defaults. It's like, a, excuse me, excuse me, excuse me, it's like a mortgage or deed of trust, but instead of, it's the equivalent if we're talking about personal property. And of course, we have a financing statement. What is a financing statement? Well, this is more commonly probably called a UCC-1, and this is a formal notice of a lien relating to personal property that is filed with the state. There's a permanent record of that until the lien gets released. And so the bank is going to file that on those 50 tables that it is financing. It perfects that creditor's interest, as we talked about perfecting the lien, perfect the interest in the collateral. If the creditor doesn't file a UCC-1 for personal property, he or she might be out of luck if the debtor defaults on the loan. So let's look at what that form looks like. This is, I've just gone to the Secretary of State, Texas Secretary of State website, and this is what the UCC financing form looks like. It looks the same in all 50 states. They all have this type of document, and they're routinely filed by various creditors, banks, things like that. Okay, so we're not going to go on and talk about our other items, but just keep in mind, let me go back to our first slide. We have now covered introduction to property. We talked about real property, personal property, tangible, intangible. We talked about fixtures and chattel and improvements. We talked about purchasing property. We talked about financing property with collateral. In our next lecture, we'll talk about leasing property, and we'll also talk about intellectual property rights. Thank you for your attention. As always, please feel free to come by and talk with me if you have questions about the materials. My office hours are available. Oops, I went too far. My office hours are available on my syllabus. And you can, of course, always email me at cgroover@collin.edu with questions that you might have about the material. Thanks for your attention. I hope you have a wonderful day, and I'll be seeing you soon. Oops, sorry, hit the wrong button there.